Thank you, my lord. I will now deal with count 4, causing an explosion. Section 27(1)(c) of Act 26 of 1956 determines a sentence of not less than 3 years and not more than 15 years where the causing of danger to life or property is willful. In caso this was exactly the situation, it is submitted that the sentence of 10 years imprisonment would be an appropriate sentence in circumstances in respect of accused number 1 and 2. In respect of accused number 3, because it was prior to her birthday, or her 18th birthday, having a regard to her age, is submitted that the appropriate sentence is one of 8 years imprisonment. Then malicious injury to property, count 5. More than 3 vehicles were damaged due to the detonation of the explosive devices. During 2012, the cost of repair of the vehicles of Leighton, Vrede and Grunewald amounted to approximately 13,500. It is admitted that a sentence of 3 years imprisonment is an appropriate sentence under circumstances. In respect of accused number 3, having regard to her age, is submitted that the appropriate sentence is one of 2 years. The murder charges, in terms of Part 1 of Schedule 2 of Act 105 of 1997, read with Section 51(1), a sentence of life imprisonment is prescribed for murder where it was planned or premeditated. The death was caused during a robbery with aggravating circumstances, or where the offense was committed by a group of people or a syndicate in the furtherance of a common purpose or conspiracy. It is clear that all the murders were carefully planned, premeditated, and executed in the furtherance of a common purpose and a conspiracy by the syndicate or group of people, Electus Per Deus enterprise. It is submitted that in respect of all the murder charges that one or more of the above mentioned criteria has been proved to exist. It is submitted that all the murders therefore fall under Part 1 of Schedule 2 of Act 105 of 1997 and are therefore liable for a sentence to life imprisonment in terms of Section 51(1) of the Act. Alternatively, Part 2 of Schedule 2, read with Section 51(2), provides for that murder in circumstances other than in Part 1 attracts a minimum sentence of 15 years imprisonment. In respect of accused number 3, it's submitted that the appropriate sentence is as follows. Count 8 and 9, committed prior to 21st of October 2015, 20 years imprisonment. Counts 11, 12, 22, 24, 27, and 29, committed after the 21st of October 2015, life imprisonment.
Are you suggesting that Part 81 that might be applicable?
No, that's the alternative. No. Yeah, our argument is that life is the appropriate sentence. Robbery charges count 13, 23, 25, 28, and 30. In terms of Part 2 of Schedule 2 of Act 105 1997, read with Section 51(2), a sentence of 15 years imprisonment is prescribed for robbery where there are aggravating circumstances or involving the taking of a motor vehicle. We submit there are aggravating circumstances as reflected in Section 1. I'm not going to read that out, my lord. It is submitted that all the robbery charges involve the wielding of a firearm, which make it aggravating circumstances during the execution of the robberies, and therefore falls squarely under the ambit of aggravating circumstances. Therefore, in the absence of any substantial and compelling circumstances, the prescribed sentence of 15 years imprisonment should be imposed in respect of all the robberies. Then the conspiracy to murder, the conviction in terms of Section 18(2) of the Act is liable to the punishment to which a person convicted is actually committed. That offense would be liable. So in this instance, attempted murder was the actual offense, and the actual offense was murder. Accordingly, it's submitted that in this instance, the colluded crime was murder, and the court is therefore entitled to impose an appropriate sentence as if convicted on account of murder. It is clear that the provisions of Section 51 of 105 of 1997 is not applicable, and the court may exercise its inherent penal jurisdiction. It was an elaborated conspiracy consisting of many scouting expeditions under false pretenses, obtaining personal information from Joshua Grunewald, doing a dry run, obtaining the services of assassins and providing them with firearms, digging graves to dispose of the body. Extensive surveillance was conducted at his workplace, his home, as well as his sporting venues. The conspiracy in the instance entailed the most extensive and thorough preparation of all the murders. They did everything in their power to execute the plan. The only reason why they did not follow through was due to Jacques de Villiers' unexpected and untimely disappearance. Had it not been for that fact, there would have been another murder. Therefore, this offence must be regarded in a serious light, justifying the imposition of a heavy sentence. A 20-year imprisonment in respect of accused number 1 and 2 is submitted. In respect of accused number 3, having regard to her age, it's submitted that the appropriate sentence is one of 10 years.
Isn't it harsh? It's even harsher than the alternative.
Which old?
Reference went to page 23, para 81. That murder there would have 15 years, but here attempted murder 20 years. So.
Yeah, but that's the minimum sentence, my lord. It's not the maximum. So the court is obliged to impose a minimum, but the court has also the jurisdiction to impose more than.
I know that, but I think, you're suggesting 20 years for the attempted murder.
Yeah, but the minimum sentence does not apply.
Yes, I know that.
I follow the court's correlating now.
I'm trying to understand how you get to 20 years, recommendation of 20 years.
My lord, it is due to, they did everything.
What's contained in para 87.
Yes, that's good. That's our motivation for that.
But my sense of justice dictates that. I think that might be a bit harsh.
My lord, whether 15 years, 20 years, 15, which would be then what the same is as a minimum sentence in terms of part 2, would also be, might be an appropriate sentence. The fraud of discovery, my lord, count 19. The fraud charge attracts a minimum sentence in terms of part 2 of Schedule 2 of Act 105 of 1997. Where the charge involved fraud involving amount more than 500,000 rand, involving amounts of more than 100,000 if it is proved that the offence was committed by a person, a group of persons, syndicate, or an enterprise acting in the execution of or furtherance of a common purpose or conspiracy. Accordingly, in the absence of substantial compelling circumstances, it is submitted that the prescribed minimum sentence of 15 years imprisonment be imposed in respect of accused number 1 and 2. Accused number 3 was not charged with that. Count 14 to 18 and 20, various fraud charges and defeating any cause of justice. All these counts are the so-called secondary offences in order to achieve the successful payout of the fraud against discovery. Count 19 is submitted that an appropriate sentence is 1 or 3 years imprisonment on each of the counts for accused number 1 and 2. 3 was not charged. Count 26 is fraud with the credit cards. It's submitted that an appropriate sentence is 1 or 3 years imprisonment in respect of all the accused. The illegal possession of firearms, Part 2 of Schedule 2 of 105 of 1997 provides for a minimum sentence of 15 years for any offence relating to possession of an automatic or semi-automatic firearm. The three of the firearms of which the accused were convicted for possession of are semi-automatic firearms. Therefore, in the absence of substantial and compelling circumstances, submitted that the prescribed minimum sentence of 15 years imprisonment is an appropriate sentence. As regards to the possession of ammunition, it is evident that the vast number of ammunition was discovered at Kosana Flats as well as at the classroom of Marinda at Jan de Klerk Secondary School. Submitted that an appropriate sentence would be 3 years imprisonment for the 3 accused. Lord, then we summarized what our proposals are from page 27 to page 32, and I might just add I'm not going to read that in because it will just be a duplication. If I can only then deal with from paragraph 107, in terms of section 208(2) of the Criminal Procedure Act, it should be ordered that the sentences in counts 2, 3, 4, 5, 8, 9, 10, 13, 23, 25, 26, 28, 30, 31, and 32 are to run concurrently. Ex lege, these sentences will run concurrently with life sentences in terms of section 39(2)(a) Roman 1 of the Correctional Services Act 111 of 1998. All sentences to be served will run concurrently with any life sentence. In terms of section 39(2)(a) Roman 2 of the Correctional Services Act 111 of 1998, all life sentences are to run concurrently. Furthermore, no order is to be made in terms of Section 103 of the Firearms Control Act, number 60 of 2000, and the accused are ex lege automatically declared unfit to possess firearms. Therefore, my lord, our submission is that the effective sentences for the 3 accused before court should be that of life imprisonment.
Let's assume that I was to find that there are substantial and compelling circumstances in respect of accused number 3.
Yes, my lord.
And let's assume I find that, where you've proposed a life imprisonment, I find that it's 15 years. Are you with me?
I'm with you, my lord.
What would the sum total of the sentence be in respect of accused number 3? Of the proposed sentence?
If the most serious offence attracts a sentence of 15 years, then and the court orders it to run concurrently, the proposed sentence of accused 3 will be 15 years. But then, my lord,
what about the fact that I think State versus Marcel talks about that in certain instances, I think, where there's a close proximity in terms of time, date, etc. Some of the offences should run concurrently. But wouldn't 15 years be too light a sentence, for what she's done?
Indeed, my lord. And it would also be problematic in the sense that the courts must strive to consistency, my lord. And then our submission, our alternative submission would then be, if the court should find that there are substantial compelling circumstances present in the case of accused number 3.
Yes.
Our alternative submission would be, my lord, then the court would have to look at at Lex LaRue Steyn. LaRue Steyn was in a similar position as accused number 3. He was also a minor prior to the 21st of October 2015. He was also subjected to this cultism, to this bad upbringing, and everything which applies to accused number 3 also applies to him. The age difference between the two are very small. It's only 2 years. And then, my lord, our submission would be that the correlation should be made between the sentences that he received after a plea bargain, which made his sentence a more favorable one because he, from the start, played open cards with the police in the first place, and then thereafter with also the state, approaching the state for a plea and sentence agreement, whereby a harsh sentence was imposed with a suspended portion on condition that he testifies. So his effective sentence was 25 years. So for the murders.
He was initially given
35 years. And 10 years with suspended on condition he testified. So
again, I think I thought made up my mind. It's obviously going to be subject to what arguments I hear. But let's assume that I find that, and maybe let's just, I'm trying to work this out in my own mind.
yes, my lord.
So you're saying that when you're submitting that she might then have to get an effective how many years?
35 years now.
35.
Yes.
Usually I think a person, will that not be longer than life?
No, my lord. There's
obviously, look, with the minimum sentence, and I think when it comes to life, you're only eligible for consideration for parole up
Yes.
to 25 years. And if a person gets sentenced, and let's assume that she gets 30 years, she would serve what?
a third. 2/3. Half of the sentence.
Not a third.
No,
Half.
half.
So it will then be 17.5 years
Yes,
eventually.
yes. Then she's eligible for parole.
No. If I impose 35 years,
Yes,
would she serve half of that?
at least. Yes,
And obviously, if she gets life, that would be 25 years.
yes.
And then she's considered, she would then become,
Yeah.
She might be
considered for parole, yeah.
Doesn't mean that she will get parole.
No.
And what message I think what I'm sending out that, again, is bearing in mind that it's not just the once-off killing that are taking place.
Indeed, my lord, that is what we try to emphasize in our argument, is that was it a one or two? But it's a series of crimes being committed over a long period. And it is the most serious crimes being committed. And the message can't be sent out to the public out there that if you kill people for this flimsy reasons, you will only sit 17 or 20 years imprisonment. That will be the wrong message. And that is exactly what the authority is warning against, that the justice system may fall into disrepute.
What about the element of mercy? I think we've not addressed, is there a factor to be taken into account?
Yes, my lord, except if no, I haven't addressed it because we are aiming for the minimum sentence being life. So being life.
But the issue of mercy does arise, doesn't it? Deciding which should be.
Mercy should arrive if the minimum sentence is in life. Once life is a minimum sentence, mercy cannot play a role if there's no substantial and compelling circumstances. If the court wants to take that as a substantial compelling circumstance, I don't think that would be the correct approach.
So it's something that when it comes to if it's life, mercy is not a factor.
Not a factor to alter the minimum sentence.
Yes.
There are other factors which the court may take into account. And then that, once the court has to decide on a different sentence, then mercy can play a role. Because that is why the legislature has imposed minimum sentences. They, as the one case quoted, they want a unified approach by the courts. There must be a unified approach. If you kill people, if you kill many people, you should go to prison for life.
I think, wasn't there a judgment, I think, State versus PV, that deals with substantial compelling circumstances? I think it says that if the court got some sense of that you might be perpetrating an injustice, there must be, that might be in fact indicating that there might be substantial compelling circumstances present or not here. I think it's State versus PV, but I don't have it from
Lord,
it really deals with what, how will a court know that you're not committing an injustice when it comes to the issue around substantial and compelling circumstances?
therefore, it must be such extraordinary circumstances. It must be substantial and compelling. It must compel. That's the only other way the court can look at it. Once the fact is before the court, and it is compelling the court to say this is not a case for the minimum sentence. But once again, that is why the SCA warned against presiding officers without valid reasons resorting to found substantial and compelling reasons to be present for any whimsical reason, because he feels uncomfortable. But that's not the question. The question is, Parliament has ordained that for this type of crime you must go to. Looking at the violent situation in the country, for those crimes you must go to jail for life, and that is the minimum.
Is there a distinction factor between LaRue Steyn and accused number 3?
Yes, LaRue Steyn came forward immediately and participated and assisted the police. That's the first thing that distinguishes him. We have had testimony from I don't know whom, but that the police approached Marcel. I think she gave the testimony herself. They approached her and asked her to give her assistance to them. She refused it.
Didn't she mention that she was tortured?
Yes, she mentioned that.
Yes.
But be that as may, my lord, she discarded that opportunity and that invitation from the police to come forward. And that's a distinction. I'm just drawing distinction now between LaRue and Marcel. Thereafter, LaRue entered into a plea bargain.
He had taken responsibility for the deeds that he committed at an early stage.
Yes, at the early stage, and he assisted the police. I think there's also evidence before the court that as a result of his assistance, all the firearms were discovered. They had Kosana flats. Was it not for LaRue, that wouldn't have been the case.
What about the fact that the accused have spent 3 years in custody? More than 3 years.
Yes, my lord. That is once again a factor, but not to be taken into account when the minimum sentence is applicable.
Would that be a factor to take into account maybe if I decide that there might be substantial independent circumstances in the instance of case number 3?
Yes. Then the court should consider that as another factor as well.
He spent 3 years in custody.
Indeed, ma'am. No further submissions. Thank you, my lord.
My lord, may I hand up a signed and a clearly marked page? It's for the court. I noticed that the one I sent was not numbered.
I didn't I just read
As it is, my lord. First of all, we stand with our heads of argument as handed in, but we also believed we dealt extensively with the law on sentencing, more specifically the Minimum Sentencing Act, the Correctional Services Act, concurrency, as well as cumulative effect. I beg not to proceed with that, but move on only and base my argument with regards to the court finding compelling and substantial circumstances.
Before you deal with it, if I was to find that there are no substantial circumstances, the issue of concurrency then becomes evident.
Indeed, so that is why I said let us only focus on substantial and compelling, as the state has pointed out and correctly conceded. The rest will all be academic. My lord, I would like to refer the court to paragraph 11 of page 6 of the matter of State versus Dodo, 2001-1, SACR 594. Paragraph 11, where the Constitutional Court through Judge Ackerman endorsed the interpretation of the words substantial and compelling circumstances in section 51 sub 3 and a detailed step-by-step procedure to be followed in applying the test to the actual sentencing situation. Ackerman J said at CP 63, and I quote, the interpretation as an...
Page 6 of your heads.
Indeed, so my lord, paragraph 11. This interpretation as an overarching guideline is one that this court endorses as a practical method to be employed by all judicial officers faced with the application of Section 51. It will no doubt be refined and particularized on a case-by-case basis as the need arises. It steers an appropriate path which the legislature doubtless intended, respecting the legislator's decision to ensure that consistently heavier sentences are imposed to the serious crimes covered by Section 51, and at the same time promoting the spirit, the purpose and objectives of the Bill of Rights. The step-by-step procedure, and then I can just refer here, it is very clear that each court, each sentencing officer should deal with each matter on its own facts and merits. That is a constitutional court's decision. And then Marie J.A. at paragraph 25, I quote the following, the step-by-step procedures starting at paragraph...
Would there be a reference to Malchus?
Indeed, so much. Okay. At capital B, courts are required to approach the imposition of sentences conscious that the legislator has ordained life imprisonment or the particular prescribed sentence as the sentence that should ordinarily, and in the absence of weighty justification, be imposed for the listed crimes in the specific circumstances. The starting point then indeed, in our instance, I'm arguing only with regards to the life imprisonments. Unless there are and can be seen to be truly convincing reasons for a different response, the crimes in question are therefore required to elicit a severe, standardized and consistent response from the courts. The specified sentences are not to be departed from lightly and for flimsy reasons, speculative hypothesis favorable to the offender, undue sympathy, aversion to imposing first offenders, imprisoning first offenders, beg your pardon, personal doubts as to the efficacy of the policy underlying the legislation, and marginal differences in the personal circumstances of degrees of participation between co-offenders are to be excluded. My Lord, I would like to emphasize the reference to speculative hypothesis, as I heard the court entering into this aspect with the state with regards to accused number one's possible defense. I will return to that. The legislator has, however, deliberately left it to the courts to decide whether the circumstances of any particular case call for a departure from the prescribed sentence, while the emphasis has shifted to the objective gravity of the type of crime and the need for effective sanctions against it. This does not mean that all other considerations are to be ignored. All factors, other than those set out in the above, traditionally taken into account in sentencing, whether or not they diminish moral guilt, has continued to play a role. None is excluded at the outset from consideration. I would also return to the moral guilt, my Lord, in reference to the accused personal circumstances. None is excluded at the outset from consideration. The ultimate impact of all the circumstances relevant to sentencing must be measured against the composite yardstick, substantial and compelling, and must be such as to cumulatively justify a departure from the standardized response that the legislator has ordained. Lord, what I understand here, to say the accused is a first offender, and that is the only circumstantial evidence, compelling, is not what we are doing. We are taking cumulatively his personal circumstances as set out before this court and accepted, undisputed as it is, as well as the specific facts which the court has found and based its convictions on. We are referring to that as...
Could you remind me what those are? Because...
Yes, with regards to the accused personal circumstances, I will refer...
Obviously, he's a first offender.
Yes.
How old is he?
He is, my Lord, that is page 10, paragraph 22. That was contained in Exhibit 5 times T. He is a first offender. He's currently 34 years of age. He completed a BCom degree in actual science, and at the time of his arrest, he was self-employed and earning approximately 70,000 rand. The court did take that up with Ms. Vergeer, and it is clear that that was the last 2 months. Prior to that, in excess of 100,000 per month. That was on record by the state, not by the accused. He has been...
Of course, there were those contradictions between what was said in open court and what appears in the report.
My Lord, I think the witness did attempt to clarify that according to her knowledge, the last 2 months before accused then committed the Cecilia Steyn incident, he was working for himself on the...
I think he started his company in June 2015.
Yes. She indicated what she gained from the accused was the last 2 months prior to him disappearing. That was his income, and that is why she mentioned that. He has been in custody for approximately 3 years and 2 months, and then indeed he was married to the deceased, Michaela. Now, the facts which I would like to reiterate with regards to accused one is the following, and that is facts that was accepted, not only by the evidence of the accused, the state. Also placed this before the court. The accused was a well-adjusted, happily married, earning an above-average income, educated and relatively young man who, according to evidence, was a practicing Christian believer. His whole life took a turn to the worst after becoming involved with the OTC and meeting accused and Miranda Steyn. It is common cause that the initial crimes prior to the murders of the Meyer couple were committed due to accused two wanting to take revenge on Ria Groenewald and her manipulating the accused into believing that these crimes had to be committed for the greater good. It is to protect her, accused two, first of all, from satanic attacks, and to protect and to provide for orphan children. This would include that the accused wife, Michaela, had to be eliminated as she had become a threat to the existence of the group Electus Per Deus. My Lord, the evidence from the state was there was no financial gain. What other was the reason than this in our submission? The accused two wanted these victims to be killed for her own personal gain, to further her beliefs, to further her control, to get rid of her arch enemy, Ria Groenewald, who was the only person openly standing against her.
Well, isn't that the sad part of this, that accused one initially had meant to do well.
Indeed, someone.
He plowed a lot of money into this non-existing orphanage.
It's a
He came from a very good family background, and then believed, all the lies that were fed to him about
yes.
a non-existing, orphanage. He made inquiries as to where the orphanage was. Told that no, we can't disclose that, because once we disclose that, it will just the witches of the Satanic Church will then know where the orphanage is and harm them.
It's my Lord, I'm going to come to the question which the court posed to the state. Why did accused one or others act the way they did?
Yes.
I would like to possibly give my submissions.
Yes, no, of course.
If we can just deal with exactly what the court has just now said, that it is also common cause that accused was drained financially by accused 2 under the above auspices that he was only doing good. The Honourable Court has ruled that accused 2 was the manager of this Electus Per Deus. Again, going to what accused number 1 gained. It is further common cause that during 2015 to 2016, accused 2's constant flow of cash from whichever source had drastically decreased and that she needed her food soldiers to proceed in committing crimes. Thus, the Mayors as well as Jared Jackson was murdered. The evidence of Ms. McNabb on behalf of accused 3 is insightful and should be seen also relevant to accused 1's position in as far as it refers to a finding on the inner workings of a cult. My Lord, that is evidence on record. The state has not disputed. That is how a cult functions. That is how it starts. That is exactly, I think the witness even directly referred to accused 1 being under the same situation as accused 3. Though she didn't deal with accused 1, it is not his report, but I take it and I request the court to accept that that is relevant to accused 1 as well. The inner workings of the cult. It's not
I didn't make any finding that it was a cult. I found it was an enterprise.
Yes, my Lord, the evidence as I take it or understand it in terms of section, I think it's 274 of the Criminal Procedure Act, the mitigation by way of the witness, be it as expert or a defense witness.
No, I'm
there.
just saying I didn't make a specific finding.
Yes, no.
But I think she drew comparisons between
Yes.
the various
What happened?
elements of the cult.
My Lord, it actually opened my eyes to what she was saying, that this was a cult. It fitted the puzzle of what was happening 100%. Every trademark that she mentioned is relevant to the Electus Per Deus. And that is why I say accused 1 should also be taken in the light of what her evidence is. It's on record that accused 1's religious beliefs were exploited to draw him into this cult, based on his wanting to do good or to do good in the eyes of God. That accused 1 was manipulated and brainwashed, and even as much as being under the spell of accused 2 cannot be denied. It is evident from the evidence on record that the heinous crimes committed are not reconcilable with accused 1 and his prior history or his personality. It will be submitted that Ms. McNabb made it very clear that accused 2 succeeded in drawing people into a belief system, manipulated them into committing horrible acts due to the beliefs imprinted on them. Ms. McNabb pointed out that even both accused 1 and 3 can be, though both accused 1 and 3 can be accepted to be of high intelligence, accused 2's power and control usurped this. It will be submitted that it is evident from the state's case as well as the evidence of the accused himself and accused 3 that the accused had gained nothing from these crimes. He suffered extreme financial losses. He spent a significant period in hiding, even as far as being homeless. He was not the manager of this enterprise. The motive or reasons as to why he committed the heinous crimes would seem to be due to the accused 2's brainwashing him to such an extent that one could almost not resist him acting as he did. It will be argued that this may be accepted as not only mitigating, but as well as also substantial and compelling. My Lord, the question of why. Why did the accused do what he did? I 100% concede he did not voice. I acted because of being brainwashed. I acted because of being under accused number 2's spell.
And there were just some suggestions to some of the witnesses that he might have been brainwashed.
My Lord, let us set that aside for a while, accused one's version. Let us look at the evidence by state witnesses.
Yes.
Candace, Ria, and various other witnesses all testified to the exact same expectations. Control, manipulation, being bled dry, being ridiculed, being told what to wear, not to wear, what to do, what not to do, being given tablets, sleeping tablets, being unaware what I did and didn't do. That is Ria Groenewald, an excellent witness for the state. We cannot ignore that evidence. Now, accused doesn't come and say to this witnesses or to accused two, on this day, you gave me this and this tablet that made me hallucinate or come unto your spell. He does not say that. And my lord, there's an obvious explanation.
I think the closest that he came to was when he said that he was on his way to Peter Steyn after clearance. I think.
Indeed so. And accused number two, forever bare denial. I did nothing to you. I know nothing what you're saying. This didn't happen. I never did anything. That is indeed so. And it is clear even from Michaela's mother. When she visited the accused in prison and asked him, but what was happening? He recited the story like an automate, something like a robot.
Yes.
Is that not something that it's clear it was imprinted in him? This is what you say when you are confronted. This is what happens. This is how you talk.
What power did she have over him?
My lord, it seems like accused like in the exhibit 5x T, in Ms. Vergeer's report on accused one. Like his parents said, he was intelligent, but he was gullible. Soft person, gullible. And it seems accused number two, according to Ms. McNabb, played on those, I don't know how to call it shortcomings in your personality. Let's call it soft spots. He felt accused number two is sickly because that's what she told everybody.
But Ms. Snell, he's a Christian. He grew up in the Baptist church.
Yes.
He's born again.
Yes. Yes, my lord. Yes. Can I
still, believe all of this?
On that aspect, I have a specific answer, my lord, that Ria Groenewald, a Christian to the core, I would say exemplary Christian, opened her eyes, or had her eyes open at a stage, but she still went along. Can we now fault accused one that his eyes didn't open at the same time as Ria's, or Michaela's, or the other group? Can we fault him? We cannot say what hold she had on him. That is not an answer I can give to this court. And what made him think or give her that control? I cannot answer that. We see Steyn.
Yes.
When did his eyes open? When his back was against the wall. He was one of the first people arrested. Then he spilled the beans. He didn't try to run away earlier. I do not want to give my opinion on his religion. That I cannot, because that's not before the court.
And of course, I think it's up for us to judge them on that
yes,
part of it.
Each and every witness had a different time of his or her epiphany, opening of the eyes. Accused one might still decide I'm still believing accused two. That is not for us to answer, my lord. What was the actual, they call it in Afrikaans dryfveer, behind him to act that way?
Driving force.
My lord. That is clear. It was accused two's influence and control. And that is why, and I'm not going to refer to the specific.
But he's never put that to accused number two when he testified. So, and this court has been denied an opportunity to have seen, I think, what her response was going to be. He's never put to accused number
My
two.
lord.
That, you had brainwashed accused number one.
Well, it was put to her that she was lying about the orphanage, that she...
And I'm talking now specifically about brainwashing.
No.
Never put to her.
It was not, that specific word was not used. But as I'm saying to the court, my lord, did accused one actually realize what was happening?
Well, he says he was hypnotized. I mean, I don't know how long the hypnotism would have worked.
That's also all in the air. That's also
It was
speculation.
for a period from 2012 up to 20... with the murder of Jerry Jackson.
Yes. My lord, I concede that is maybe a bad choice
And
of
that's still
words.
during the hypnotism, he still made a lot of money at his workplace.
Yeah, my lord, it does not make sense to say I was hypnotized. I concede to that. But I'm
So
begging.
why does he use the word hypnotize? And that appears in the probation officer's report.
My lord, that is how he describes his condition. That is what he says, that is his condition. That is how he acted under that condition. He's not saying, he's not voicing the word brainwash. May I use the word indoctrination? That is also brainwashing. That is the same story, and I will get to that in my last matters that I referred to, the case where I referred to. My lord, what I was saying, let's divorce, accuse one's own words. Let's stand on the state's words. It is clear. Something happened between accused 1 and 2 that caused him to go into this killing spree.
Well, I think, to remember, I think the witness, I've forgotten his name, was with him at, when he was in hiding, and before he started
Yes.
working for Kia Kaham.
I also forget the name.
Didn't he say that accused number 2, or accused number 1, had hoped that accused number 2 was going to become his wife or something along those lines?
My lord,
Do you recall that?
I recall that, yes.
So didn't he have this infatuation with accused number?
That is also a possibility created by accused 2 again on the basis of getting control. That's mind control. Promising you, like the witness said, Ms. McNabb, almost grooming, like we see with minor children in rape cases, grooming you in the best way I can get control of you. Be it to say I'm in love with you, whatever, getting that form of control. And that is my submission, my lord.
But accused number 2, accused number 1 was part of the killing machine.
Indeed so.
Because I think him and
The
LaRue
court has convicted him.
Miranda and accused number 3 and John Barnett, I think, were all part of the killing machine.
Accused,
What was he fearful of?
my lord,
He's part of the murderous group. What did he fear?
let us divorce the first murders where it is my submission, as I said in my head, to protect accused 2 and the children. Those were the initial driving force.
And those would have been spiritual and biblical.
Indeed so. What went wrong, as the court has convicted accused 1 on Jared Jackson and the Mayers, I cannot answer, my lord, on that. Because that is, initially it seemed to be financial. And it's still the version of the state that the Mayers were supposed to have a lot of money.
Yes.
It didn't transpire. Jared Jackson would replace 3.5 million would go to accused 2. Accused 2, my lord. Again, giving accused 2 what she needs. Money now, no more protection. And my lord, that goes on the accused moral blameworthiness. Those last 2 incidences. And my lord,
So what are you submitting? Are you submitting that perhaps a different sentence should be imposed for killings that might have had some religious
No, no.
connotation?
That is not what I'm saying. I'm saying,
Or what are you submitting to me?
I'm saying, my lord, the initial driving force, according to the evidence, for accused number 1 to have done what the court has found he's done, was to assist accused 2 and children. The second instances was still to assist them. So it's still under the same auspices, but with the other end game, if we can call it that.
What happened to this beautiful young man whom Michaela's mother had entrusted a daughter to, who then turned out to be a monster, a killing machine?
My lord, I think it is clear when we look at the description of a cult, becomes an empty vessel where whatever is placed in him has become evil. And what is also relevant, my lord, is the moment accused number 1 is removed from the equation as the actual killer,
Accused 1 or accused 2?
accused 1
Okay.
is removed because he has to be in hiding. I'm only dealing with the facts on record by the state. He's replaced immediately and very easily by John Barnett and LaRue Steyn. very, very easily.
Well, he wasn't really replaced because, if you recall, I think Steyn was going to take part in the murders of the Mayo couple, and because I think he shot himself, couldn't take part in it.
Maybe
And he was then replaced by John Barnett.
maybe I should put it in a different
And I
angle.
think also when it comes to Jared Jackson, I think he wasn't really a replacement.
Let me put it in a different angle.
Yes.
Nothing stopped when accused one didn't continue his participation. It actually went on. It actually became worse.
Yes.
So accused one cannot be said to be the center of this. That's again indicative of him only playing a minor or a role, not being the manager.
As a foot soldier.
Yes, indeed. That is the findings of the court.
Yes.
Now, one should also not lose sight of the fact that this honorable court has acquitted accused one. All the other witnesses, and his previous and co-accused, the witnesses being Leroux and Barnard, had actually executed the last murders.
Yes.
We should not forget about that. And he should.
Do you think I was wrongly acquitted, sir?
No, my lord. I say one should remind ourselves in that regard.
Yes.
And not speculate on what would have happened if he didn't hide or what. He was not part.
Well, of course, I think there was insufficient evidence,
Yes.
and I think we had a debate about what Miranda had said, Leroux had said, I think, and there was inconsistency.
Indeed, sir. My lord, let me move on then. In closing my submission is that I would like to refer the court to page 14, paragraph 27, where I deal with specific matters. And I would like to proceed there. In the light of the uniqueness of this matter, the defense could not find case law of similar nature and close in facts that could be used as a guidance with regards to appropriate sentence. However, we will refer the following matters. State versus Matlatsi, 2013, volume 2, SSC R625 GMP. The appellant was convicted of a variety of crimes and sentenced to an effective term of 50 years imprisonment. On appeal, it was held that the court should not impose sentences that exceed life imprisonment of 50 years. In State versus Aysen, my lord, I'm not going to delve into that. The state has conceded you have either you give the life imprisonment for the racketeering because you are imposing life imprisonment for the predicate sentences, or vice versa. Aysen, in fact, said 15 years for a gang leader who also committed various common law and other offences.
How many murders did he commit?
I could not find that he committed murders, no. Initially then,
And of course, I think the murders are much more serious.
Yes, indeed, sir.
And robbery.
I concede that.
And housebreaking.
I concede that, my lord. Just, as I said, I could not find matters close in fact to our matter. I'm just referring to racketeering in Aysen. Now,
Wasn't that matter, I think, the serial killer, I've forgotten his surname, I think,
there's one from Western area that was sentenced in this court for various rapes and
who
murders.
operated in the Wemapen area.
Yes, that is one of the older ones, my lord. That was not gang or racketeering. That was a single person. I could not find a group acting as we are dealing
Yes.
as a court pleases. Now, in State versus Lata and another 2012 volume 2 SACR 30 BCG, in this matter, the two accused, as a result of the influence that Witchcraft had on them, murdered the deceased whom they believed was bewitching their family. It was held that they had labored under delusion due to the influence of Witchcraft, and even though this did not alter their guilt legally, it did palliate in some measure the horror of the crime. It was found that this constituted extenuating circumstances. They were sentenced to respectively 20 years with 5 years suspended and 15 years with 5 years suspended. My lord, I'm likening Witchcraft, and that is very murky waters. I don't want to go.
Well, except that I think in the Slaughter matter, this was about, they believed that the deceased was murdering their
Yes.
family members.
Yes.
All the deceased were not related to accused number one.
No. Accused number one, if we look at the facts, believed initially was protecting accused two. That is why I'm likening it to this
But,
matter.
Pastor and Dixon, when Dixon gets murdered because he stole Cecilia's sermons.
Yes. Well, these people murdered a person they believe bewitched somebody else.
A family member.
Yes, yes. Now, State versus Massina and Anderen, 1993, volume 2, SAC 2340, it was held that the person who had been subjected to prolonged and intensive indoctrination, causing him to believe that his actions are those of a soldier and freedom fighter, and upon whom it has been impressed that the assassination of a specific person is permissible, and he believes it is in respect of a murder committed by him as a result of such indoctrination morally less blameworthy than a person who has not been so indoctrinated. My Lord, indoctrination is the central theme. Indoctrination in you may kill these people because they are opposing Electus Per Deus. We see the Old Testament being used, you may kill because of this. This is exactly the same matter. My Lord, I'm asking the court in closing.
But then no reference is made to the New Testament.
No.
And if one grows up in a Christian environment, born again.
Indeed, so my Lord, that goes to the extent of indoctrination. How far did she manage to indoctrinate that we even only focus on the Old Testament? Indoctrination to believe I'm a freedom fighter, I'm an assassin. What does that mean, my Lord? It's the same story. You take a person, you empty him of his beliefs, and you put in that vessel whatever you want, and you pull the strings like a puppeteer.
But what have you got in inverted commas? No, in practice there.
I said it's
Page 15.
due to lack of adequate factual basis, the majority decided that this could not be accepted as extenuating circumstances.
And was there any factual basis for the claim of indoctrination before me?
My Lord, no. I can just add that it is our submission. Cumulatively, because personal circumstances, the facts of the matter, specifically the facts of the matter, and accused one's involvement and how it happened to him to be, may be by this court found to be substantial and compelling and to deviate from the life imprisonment. I am not subscribing to the court any specific sentences.
But then, was now, he had started his own company called Deity Trade.
Entire day.
Entire Deity. And decides to make accused number 2 as the beneficiary of this policy.
That goes back to
Then
the
comes
wife.
with an elaborate plan, to break this debt
Indeed, my Lord, that
by
is what
having
the court
Judge
found.
Jackson killed in this place.
That is what the court found.
That how can that be substantial and compelling?
My Lord, it goes back again to the why. And I stand by my submission, because one would not have done what the court has found is done, had it not been for the circumstances it used to place me.
I know that you say that you're not prepared to make any submissions as to what sentences I think.
No, my Lord. The state has prescribed specific sentences to the court. I would not. There are minimum sentences. I dealt with that, my Lord, on each specific count. I am not going to suggest any.
You don't
It
want
is
to suggest-
academic, my Lord. Other
Even
than
if I was to try and push you to indicate, I think, as to what might be just, but rather not to go that far.
no, I would leave that in the hands of the
Of
court.
course,
my Lord.
okay,
Thank
I
you.
understand.
Thank you.
I'll give you for you, sir. What would be I think I've dealt with all my questions.
Is it good? Thank you, my Lord.
Mr. Kutsai.
The court pleases, my lord. My lord, the defense on behalf of the accused do stand or for that matter for the content of the hit. I would just like to emphasize a couple of facts pertaining specifically to one issue, and that is the question of whether there are compelling and substantial circumstances. Now, my learned colleagues have cited numerous cases. I wish to only cite two, where it was said in Malgas. For circumstances to qualify as substantial and compelling, that need not be exception, in the sense that they are seldom encountered or rare, rather limited to those which immediate the moral guilt of the victim. And then also to the State versus Velikati, the 29 matter, 1 SACR 52, Supreme Court. The court explained the particular factors, whether aggravating or mitigating should not be taken individually, where they said, aggravating or mitigating should not be taken individually and in isolation as substantial or compelling circumstances. Ultimately, in deciding whether substantial and compelling circumstances exist, one must look at the traditional mitigating and aggravating factors and consider the cumulative effect thereof, as many other sightings also we talked about. Now, my Lord, the State has also questioned the probation officer, are there compelling or substantial circumstances? Obviously, she said no. It is for the court to decide whether there are or are not compelling or substantial circumstances. And when we look at the personal circumstances of the accused, the unfortunate thing is that we are none the wiser with regard to the real personal circumstances of growing up, because there are conflict. The conflict between what the accused says and what the accused parents say. And there's no corroboration, so we cannot take that any further.
It does not show that she's got a propensity to tell lies.
Well, I understand
And there
what the court is saying.
there is a difficulty, I think, that the probation officer had.
Yeah.
And she then responded with such a sarcastic, response that in any event, God should then be called as a witness to decide if I'm telling the truth or not.
Well, there again, the probation officer didn't say it was sarcastic.
But let's look what appears in the report. You've seen that.
Yes. It may be construed as being sarcastic.
Which paragraph would that be again? Because I think it's on page 20. Or maybe if you look at, let's start at page 19. Maybe just want to read from the last paragraph.
The prejudice about the current disposition. The accused became more emotional, and I think that is important. Emotional, the undersigned indicated that she could not write the report about her as it would or could possibly affect her negatively. The accused then said that, now quote, judge should call upon God to come and testify if they are not content with the version.
It's almost like you, probation officer, don't believe me. The Scott didn't believe me.
Yeah.
Maybe the judge should call God to come and testify. If he's not content with my version.
It's a subjective thing, Lord. It's like someone who said, well, I swear, you call God as a witness. When does one construe it? It is a subjective matter. But is that aggravated, like the State requested to want to take into consideration?
Well, of course, I think, I can't call God as a witness to testify. Yeah.
Absolutely.
But if one looks at the factors of the circumstances of the accused, what we know, I think, is that she was first married to allow, I think, a person to get a green card, probably not green card. That time, I think we used to have the card to be green. Yeah. And then was she married how many days? 3 days? 5 days?
Yeah, I think it was.
And then she got married to her husband. They've got two children. She went up to grade 9. She had denied, I think, that she was involved in any of the incidences. She's spoken about how traumatized I think the children were due to the coverage that took place in this matter. Very substantial complaints and cases. Shouldn't there be something more?
It is indeed so, Lord. I just want to, if one...
These are just standard mitigating factors.
So again, Lord?
These are just the standard mitigating factors.
Yeah.
You know, I'm married, I've got 2 children, I've been in custody for 2 years. I can't show remorse because I didn't do anything wrong.
I think when one looks at my head further, actually, I'll get there. If I may just carry on with regard to the personal circumstances.
Yes.
Now, it cannot be denied that she has been in incarceration from 2016.
Yes.
That is a fact. She has minor children, and that she has a medical condition. I know that the state argued that a medical condition is exaggerated. It's a fact. She has a medical condition. She's been treated in prison. Cannot be denied. But that, my submission, those 3 factors at least should be pursued for mitigating circumstances for this honourable court to decide whether those mitigating circumstances fall within the ambit of substantial and compelling. But then I'll go further. If you look at point 2.4, the gravity of the offence, is it conceded? The defence conceded. Nothing denying that the offences which the accused have been convicted of are of extreme serious nature. It was further found by the court that all the crimes were planned, executed under the leadership of the accused. Several people lost their lives and many families have been devastated. Now, when one looks, I've already dealt with the 3 mitigating circumstances I wish the court to consider. To look at the conclusion, defence concedes further that the aggravating factors in the crimes committed by the accused far outweighs the personal circumstances. That's a fact. It would be futile for me to come and argue else. In these circumstances, retribution and deterrence come to the fore, and the accused's personal circumstances are reduced to the background. And, my Lord, in recommending a possible suitable sentence, the defence respectfully submit that the court is in a much better position to decide because of the fact that you have all the evidence. It would be very subjective from me to come up with a number of proposals. And I know that this court is very well equipped to come to a proper. That is my submission.
I think it would be improper for me to push you.
Well, let's hear the number.
No, I'm not going to push you.
That's a court precedent.
But this is probably one of the worst matters that I've sad about. But you stand by your heads of arguments.
I stand by my Lord. It would be futile. The evidence are so overwhelming. We need to go back then prior to the judgment if I wish to bring anything else up. I think that the accused had the opportunity.
And that defense really was just a bad denial. And later, I think in this report, there's some allegations that she was framed, or the husband believes, former husband believed that she was framed
Yes.
and placed. Those explanations.
That is something that I cannot take forward without the consent.
Yes. Thank you.
Thank you.
I want to just address the court on the question of what was something on substantial and compelling circumstances, or the meaning thereof. with regard to, my learned friend has already referred the court to the case of Marcus, but I just want to emphasize that point. The court in Marcus found that it cannot be the exceptional circumstance, because the state has mentioned the word, it has to be extraordinary to be substantial and compelling. That was not the case in Marcus, and Marcus actually found that the reason why the appeal succeeded then was because the court found that the quota quo used the word exceptional instead of and relied on a previous case where Segment A used the word exceptional, and they found that the substantial, to find those circumstances, it had to be exceptional. Secondly, my lord, I just want to read into the record on page 14 of the judgment. I don't have that in my head, so I'll just read from, it's the Marcus judgment.
Yes.
It's paragraph 34. The circumstances in which the crime was committed are undoubtedly such to render it necessary to impose a sentence of imprisonment for life, unless substantial and compelling circumstances justify a lesser sentence. The shooting was premeditated and planned. The fact that the planning and premeditation occurred not long before the deed was accomplished cannot alter that. It was also carried out in the execution of common purpose to kill the deceased. Given all the due weight to the enormity of the crime and the public interest in an appropriately severe punishment being imposed for it, I consider that the personal circumstances of the accused, a relative youth, now in this case, my lord, the appellant was 22 years old at the time, and the court still referred to her as a relatively young person. A keen record, a vulnerability to Carol's influence, and I'm likening it to the situation in which accused 3 would have found herself.
How many murders were committed in Marcus?
Well, it's one murder, my lord. We can't, there's no case. We cannot compare this case to any case law because there is no case.
So this is a special type of case?
It's a special case, and of course the court...
One shouldn't just blindly follow...
No, but I am...
What the previous courts have said.
No, we
I've
can't.
got to look at the uniqueness of this method.
We do have to. The court has to consider this case and the circumstances.
Just keep on reminding me that she's been convicted of 8 murders.
That's correct.
7 murders. What's 8 murders?
8 murders, yes, and 2 of which she was under the age of 8. But if I may proceed, my lord, I'm not making the point that the court should compare everything about this case to that case. I'm making the point about substantial and compelling circumstances and about how a court can find that in fact substantial and compelling circumstances do exist in a particular case when considering all the circumstances correctly and in light of the decision in S versus Marcus. Madhu, I'll leave it there then. I want to proceed with, on page 7 of my heads, I stand by my words. That's my submission. In full, I stand fully behind my heads, but on page 7, I would like to read into the report. In the case of S versus Dodo, which was referred to by accused number 1's counsel, the Constitutional Court said the approach laid down in Marcus, in particular, that its determinative test for deciding whether a prescribed minimum sentence may be departed from makes plain that the power of the court to impose a lesser sentence can be exercised well before the disproportionality between the mandated sentence and the nature of the offence becomes so great that it can be typified as gross and thus constitutionally offensive. The court also found that notwithstanding the seriousness of the offence committed, the appellant retains his inherent worth and dignity, and this must be considered in the process of determining an appropriate sentence. The determinative test in Marcus was emphasized in S versus MM, S versus JS, S versus JB, my lord, which is full citation of which is on page 8 at the top. As follows: if the sentencing court, on consideration of the circumstances of the particular case, is satisfied that the render of prescribed sentence is unjust in that it would be disproportionate to the crime, the criminal, and lead the society so that an injustice would be done. By imposing that sentence, it is entitled to impose a lesser sentence. It is therefore incumbent upon the court to assess, upon a consideration of all the circumstances in a particular case, whether the prescribed sentence is indeed proportionate to the particular offence. The Constitutional Court made it clear that what is meant by offence consists of all factors relevant to the nature, the seriousness of the crime itself, as well as the relevant personal and other circumstances related to the offender, which could have a bearing on the seriousness of the offence and the culpability of the offender. If the court is indeed satisfied that a lesser sentence is called for in a particular case, thus justifying the departure from the prescribed sentence, then it hardly needs saying that the court is bound to impose that lesser sentence. In the case of S versus M, my lord, it was S versus JS and S versus JD. It concerned 3 appeals which the defendant was sentenced to life imprisonment. Nevertheless, my lord, all three of those appeals which succeeded, the sentences were reduced to 12 years and 15 years respectively. My lord, while a long period, further on in the judgment, while a long period of imprisonment is appropriate, the court must guard against a sentence that can ultimately destroy the offendant, either physically or mentally. There is no reason to believe that he cannot be rehabilitated and returned to continue to be a valuable member of his family and his society. The sentence must accordingly reflect both society's deep displeasure against conduct of this kind and society's concern that the offendant, as a first offender, should not be crushed under the weight of an unduly lengthy period of incarceration. Then, my lord, with regard to the following case in paragraph 17 of my aids, it was found that it remains the court's duty to impose fearlessly an appropriate fair sentence, even if the sentence does not satisfy the public. The courts also highlighted the destructive impact of unduly long sentences. In S versus Kamalo and others, my lord, it was found that it is the experience of prison administrators that unduly prolonged imprisonment, far from contributing towards reform, brings about the complete physical and mental deterioration of the prisoner. My lord, I then dealt with the sentencing of child offenders extensively in my heads. I'm not going to dwell on that. We know that in terms of the minimum sentencing act...
Is it correct? And I think Mr. Roberts made the concession that for the offences that accused number 3 was convicted for in 2012, that would not warrant life imprisonment.
No, my lord, it does not. The minimum sentencing act is clear on that in section 5160. So,
and I think that
it's not applicable.
From their heads, I think they had recommended that she be given a 20-year imprisonment sentence for that.
My lord, I think they referred to the Child Justice Act to come to that conclusion. However, my lord, I'm not in a position to prescribe sentences to the court. That I will leave in the court's hands, but I will definitely...
But it should be direct imprisonment for those offences.
My lord, I'm not so sure if it should be direct imprisonment, but it should be, yes, it should be imprisonment, definitely direct imprisonment, but I'm not so sure about the amount or the years that the state has prescribed for that. With regard to all the offences, my lord, in any event, I'm sticking by my head or standing by my head to submit that to the court that in the case of accused number 3, there definitely are substantial and compelling circumstances which the court can find and therefore impose a sentence lesser than the sentence prescribed by the minimum sentence.
See, the difficulty that I've got is that she testified that shortly after she was arrested, she wanted to speak to the police about her involvement, and then alleges, I think, that she was tortured and didn't proceed.
My Lord, I don't think she ever wanted to speak to the police at that
Well,
stage.
that's what you testified.
No, she testified that when she was arrested, she was taken for questioning by the police and then assaulted, but she never ever said that she wanted to
My correct.
come clean.
I will go back to the record, but my correct
Imagine
information
that,
was
my
she
Lord, but
wanted.
as I recall, it
And at
was-
some stage, I think there was some delay, but she had to speak to some attorney or some person. And there was that lengthy delay.
There was a
She was,
delay, yes.
it was quite clear to her her mind at that point in time that she wanted to speak to the police. But then there was some torture and some delay in speaking to some attorney or some counsel. But again, I think, I've been brought up by the transport.
Indeed, my Lord. I don't recall wanting to make any statements to the police, and I would submit that, my Lord, a person, when they're arrested, retains their right to remain silent.
No.
And I don't feel
Yes,
that...
but I'm just responding to what she had said. Of course, I think she's got the right to remain silent. And I think the question that I'm then posing to you is this. She said in court that she wanted to speak to the police, didn't speak to them. There was some allegation of torture. And then towards the end of the trial, when she testifies, then decides to come clean. What should I make of that?
Well-
in that situation, of course, I think it's somewhat different to where the people stand.
Yes, a situation is very much different.
So, so the question really is, comes down to genuine remorse.
Well, my Lord, I'll deal with the question of remorse. I will be dealing with that. But we've got evidence on record about the circumstances in which accused number 3 found herself. From the age of 10, accused number 3, and this is undisputed now. From the age of 10, accused number 3 was placed in a situation where she was introduced to accused number 2 by her mother. She was exposed to all these violent movies and Satanism, and she was made to live with accused number 2 from the age of 13. It is my submission that during that...
In 2011.
In 2011, yes, when she started residing with accused number 2, that if one considers her position as a child and the vulnerability and the influence with which she was exposed, first of all, her mother, and then accused number 2 as well. The influence must have been so great upon her. She was a child. Children are generally, and we've heard the evidence of Ms. May.
What was she told by Cecilia in 2011 and 2012? They could have affected, I think, her mindset.
Well, I don't know exactly what it was, but according to her evidence in court was that when the incidents began, or when she was forced into this position of being part of this gang that were perpetrating the crimes, she was initially told, the initial order was that if she didn't partake, Cecilia would be harmed, the children of the orphanage would be harmed, and that it was God's will. And that was the reason for the initial participation. She was in the state of being a child, of being told what to do by her mother at all times. And when she questioned this, she was ridiculed, and she would obviously have been fearful of them, having regard to her age and her susceptibility.
That when she took part in the murder of Michaela, she watched her mother killing Michaela. She had a knife on her, and they decided to take part in stabbing her once. And the reason for doing so was that she feared that she would be ridiculed by accused, that Miranda, her mother, would have told accused number 2 about it. And they would have said, look, you've got these psychopathic demons, but you couldn't, take part in the killing. It's more just taking part in that was just because she feared that she would be ridiculed about it.
Well, if one can take the word ridiculed and use it in that sense, yes, in that context, it says that. But during that incident, she did not of herself take part in that incident. She was standing in the doorway for a particular reason. She was scared. She stood there and she was witnessing what her mother was doing. And the fear that must have been going, and the trauma of that whole scene taking place there, her mother then instructed her to stab the deceased, and that was the reason why she took the knife and did that. And she then testified that immediately after that, she told her mother she can't do it anymore because her knife was blunt, because of the fact that she could not do that. She didn't want to participate further in that, in the actual killing.
But she went to the house of Pastor Ben Dixon.
Also as a bystander.
And no, not as a bystander. Well, but she was part of the planning. She knew that if she was there as a child, I think, it would not have made Pastor Ben Dixon to be suspicious about her.
She knew that very well, yes, because she was told that, and she was ordered to go with, because that was the purpose of her accompanying them to that scene. And when they arrived there, she was in such shock. She actually stood away from them, and she witnessed what took place, but not once did she go near. And my Lord, I'm going to submit that in all the crimes committed, where accused number 3 was present, or where she participated, her participation in comparison to what all the other accused in this matter did was so, as my witness described it, it pales in comparison.
Well,
she was not the one stabbing. She was not causing that damage.
Use the same example by saying that one looks at accused number 2, she didn't take part in the actual killings,
But she was the
But
mastermind.
she was part of accused number 3 was also part of the planning, report back, And she even said that, they had bought some pig heads and they were target practicing.
Well, I don't know that accused number 3 herself was target practicing.
No, but
she mentioned the pig heads, but I don't
pig heads. They were target practicing.
That may be the case.
But let me ask you this question also. Didn't she also take part? Remember, I think she said that the agreement between the group was that if one of them didn't feel quite well, they would abort her mission. Was that in relation to Pastor Ben Dixon?
That was, and in fact she did not feel well because it was the first time they dragged her to this murder, and they were supposedly going there to murder him, and that was when she became ill. And that in itself, my Lord, it shows that this was a child in a state of anxiety. Why would she become ill at that particular point?
But yet she proceeded again on another.
Because she was ordered to do so, because when they went home and accused number 2 was then informed that the plan wasn't carried out, it was a huge argument about that, and then she was forced the next day. Again, under that spell, and under the fear, and under the fear of having to be ridiculed, of having accused number 2 saying that she would be killed, the children would be killed, all those guilt trips she was placed under, the mental state.
She's highly intelligent. Wasn't she cunning,
Yes, she was very highly intelligent.
And very cunning too.
We've heard that
To come to court and this court and say, look, I've decided to come clean because I saw through all the lies that accused number 2 had fed us.
Well, my Lord, my submission in that regard is that this was definitely not a misleading of the court. Accused number 3, if one considers the evidence that was laid in regard to the report of Ms. McNabb, in regard to what she testified, from the time that she lived in the house of accused number 2, up until the time that she decided to change her aversion and come to court and come clean, accused number 3 was still under the same spell. Even during the time after arrest, even during the time that she was listening to all the evidence, she was still under that same mindset and the same spell of her mother, as well as accused number 2.
Highly intelligent person, believing that
that's true, my
accused number 3, and number 2 was the bride of Satan, could do astral traveling, could walk on water, and all of that.
There's no doubt about accused number 3's intelligence, my Lord, but there definitely is evidence that accused number 3 does not have a very high EQ, which is emotional intelligence. And the reason for that, if the psychologist psychometric tests, which were done when accused number 3 at this stage, she's now 21 years old, how would those tests have yielded those results at this stage if all that trauma and all those things that happened to her hadn't happened during the developmental stage of her psychosocial development?
Didn't she beat the system? She was able to pass and treat 6 distinctions despite having taken part in killings.
No, look, that's because of a high IQ, not a low EQ. The psychologist testified in no uncertain terms that the reason Marcel participated in these crimes is because she was easily manipulated by accused number 2, by her mother. And her development was stunted during the period of her first starting to live at accused number 2's place up until the time of her arrest, because she was forbidden to have friends, forbidden to have family, forbidden to attend church, required to be a slave.
Church, I think, and they were saying that it's the church that brought her into the situation that she's in.
Prior to her being living with accused number 2, she was brought up in a religious manner where they attended church. She couldn't attend church in the normal course as any other child could. She couldn't have a friend. She had no one to confide to. Her father abandoned her. Her mother was the only person she could turn to. Her brother and her mother were the only family she had. She was living with accused number 2. She was felt abandoned by her mother because
she went to a good school, where there were resources, schools days had spoken to her about why she was losing weight, It's almost like she basically lived in a much more privileged environment than so many other poorer people in the country.
That's true, my lord. She was, I don't think, of the poorest of poor people, and she lived in a I would call it a middle class environment. But that doesn't mean that she was not manipulated by these offences and by the situation she found herself.
Let's examine the following. She told this court that she was told that if she didn't take part in murders, she would end up like a killer. Where was she told that?
After she witnessed Michaela's murder.
Yes, but when exactly was she told that?
I can't
In relation to
pinpoint.
which incident was she told that?
My lord, I can't pinpoint that. There's no evidence of exactly in relation to which incident, but
So
it was
what should I make of it?
continuously told to her as well as Lily.
When?
That was his evidence.
What's
During the period of starting to live,
Before they started murder,
after they murdered Michaela.
Was it before they murdered the Meyer family? That she was
Well,
told that?
I'm not sure exactly the time frame, but I'm saying from the time that Michaela was murdered, she was continuously threatened with death.
It wasn't important for us to know what time frame she was threatened about, that she would end up like Michaela.
She did, well, that question never came up during her testimony, unfortunately.
Well, wasn't she trying to maybe just clutch at straws and say, look, let me just throw this in. Saying that, look, I was threatened that I would end up like Michaela.
My lord, I will stand by my report of the psychologist. She testified that she found accused number 3 to be an honest person. She never ever experienced her to be lying to her or malingering in any respect. And I stand by that. I can't
But the psychiatrist or psychologist wasn't in court when she testified.
but she did read the evidence. She had the
Reading
transcript.
that and observing a person, I think, are two different things.
My lord, I can't take that question any further.
I don't know if I've asked you this, but so she comes clean
Because she realized the deceit that she had been enduring for the past 5 years. And she realized all the lies that were fed into her and how she was being brainwashed and how she was being manipulated and what caused her to be part of this and how she felt trapped in the situation and where she had nowhere to turn.
But yet she
That
didn't
made
tell,
her.
yet she didn't tell Mrs. Skeepers, as to why she'd taken part in all of this.
My lord, how would she have done that? Mrs. Skeepers had left,
No, but-
had divorced
no, no,
her father.
no, I'm talking about when Mrs. Skeepers saw her in December of 2018.
My lord, why would she didn't
And just
go
tell her,
into
look,
detail.
she said, look, just tell the truth, you'll set you free, but didn't go into details.
Well, she didn't go into detail with Mrs. Skeepers because I think Mrs. Skeepers went there to try and rekindle her relationship with accused number 3 because she felt so much for accused number 3 and she wanted to assist her and she wanted her to know
Assist her
that,
or not?
assist her in any way that she could because she had she knew what a good child this was and she realized what all these events must have done to her and she felt a calling to go there and assist her in any way that she could.
I think that's basically what the psychologist also did. She said, look, she was sitting in court and observed certain things, and then I decided to approach you. See, it's fine because we've got a judges meeting. So can we take the judge gentleman?
As a court, please.
I've got to go to the meeting.
All right.